Welcome. Come on in. I'm going to share this out right quick to a couple of platforms. Sorry about that. I'm just sharing this out. So if it goes out, please forgive me. But we're about to get started with, I told y'all, I'm trying to keep my word. I am a woman of my word. So today we're going to be reading the Common Law Handbook for jurors, sheriffs, bailiffs, and justices. I'm still sharing this out, so y'all can come on in. Please give me some thumbs up. Say hello in the comment section. Let's get active in the chat for me. Help me to build up my audience for this video so that we can spread this good news to help wake up more people. Let me see. I want to share this. Okay, so thank y'all for the thumbs up. Thank y'all for the likes. I appreciate you all. Thank y'all for stopping by and joining me today. So like I said, we're going to be reading the Common Law book. I hope you all enjoyed the last book that we read, the UCC Connection, last week. That was a really, really great book. I just wanted to show you some other books that we'll be diving into over the next few weeks as we continue on in this journey of educating ourselves and learning more about who we are and how to operate the correct way, so that we won't have to continue this just this turmoil of having to constantly work as slaves just to live. We're supposed to be living life and living free and living abundantly and not working for anyone, making everyone else rich. And so this is the way, you guys. You have to know law. You have to know, about banking. You have to be very, very studied up and read. You have to start educating yourself. I was the one, I'm going to tell you all, I was one a long time ago that was like, I don't like politics. I'm not into all of that. I was definitely against voting and things like that. Until I got my awakening. I told you all about my awakening that started taking place maybe like 3 years ago, right after my mother died. It was actually happening before then because my son, who was about 16 or 17 at the time, he was he was coming into his own self and his knowledge of self and things of that nature. And he started to try to wake myself up, my mother, and everyone else. Unfortunately, he wasn't successful with my mother before she passed. However, I did catch on to what he was trying to relay, the messages, and I've taken it thus far. So definitely we have to educate ourselves, you all. We have to get involved with the government because we are the ones that are supposed to be making sure that these people do their job. We are the government. See, check out this quote at the bottom of this book. It says, governments are instituted among men deriving their just powers from the consent of the governed. So what do y'all think that means? To me, that means that the government gets their consent and they get their powers. They get their just powers from our consent because we are the ones being governed, right? But no, it should actually be the other way around. They're the ones supposed to be being governed, okay? So we all got it twisted. We are the people, not them. We are the people. We are the ones to be governing the governed. We are to be governing ourselves and governing them and making sure they do their jobs. And so with that being said, I wanted to go ahead and get started with the book, okay? Let me check the comments before I go any further. I want to make sure I'm acknowledging you all. For some reason, my comments are not coming up. Maybe I don't have any. Cool. So, with that being said, let's go ahead and dive into the book. So it says, Common Law Handbook for Jurors, Sheriffs, Bailiffs, and Justices. Men must be governed by God, or they will be ruled by tyrants. William Penn. That's very, very interesting, right? It says men must be governed by God, or they will be ruled by tyrants. It is the duties of jurors, sheriffs, bailiffs, and justices to resist all infringement upon the rights of the people without delay. Thomas Jefferson said, whenever people are well informed, they can be trusted with their own government. Clearly, the government cannot be in charge of deciding for themselves whether or not they should indict themselves on criminal charges or not. This is precisely why we have so much corruption in our government. It is the duty of the people to stand up as faithful and wise stewards, Luke 12:42, and bring the servants who think themselves as masters back into subjection. So let me tell y'all, before I even go any further, I promise y'all I have not read this book. I have not read this book. Oh wait, I take that back. I have read this book because I have some notes. I haven't read the entire book, but it's been a minute. It's been almost a year since I read this book. And I've only read it once. So, like, I just basically said all of this. It just lets me know that the universe is speaking to me and through me. So it says, common law is common sense. The question each jurist must ask himself is there an injured party? There is a common law principle which states that for there to be a crime, there must first be a victim, corpus delicti. The state cannot be the injured party. In the absence of a victim, there can be no crime. This is what the grand jurist must discover. The constitutions of most of our states assert that all power is inherent in the people, that they may exercise it by themselves in all cases to which they think themselves competent, as in electing their functionaries, executives, legislative, and deciding by a jury of themselves, both fact and law, in all judiciary cases in which any fact is involved. Or they may ask by representatives, freely and equally chosen, that it is their right and duty to be at all times armed, to freedom of person, freedom of religion, freedom of property, and freedom of the press. Thomas Jefferson, letter to John Cartwright, June 5, 1824. The Thomas Jefferson Papers, Library of Congress. Okay, moving on. It says, grand jurors, it is the duty of the common law grand jury to expose all fraud and corruption, whether it is in the political or judicial realm, and stop it. The authority of the grand jury is found only in the Bill of Rights. Therefore, it comes from God and not government. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. It is in effect a fourth branch of government, governed and administered to directly by and on behalf of the American people. Okay? Trial jurors. I don't know what I'm saying. It is the duty of the jury to execute justice and sometimes mercy. Their decisions cannot be second guessed. The jury shall have the right to determine the law and the fact. The New York Constitution, Article 1, Section 8, as understood at common law and used in constitutional provision, jury imports a body of 12 men. State versus Dalton, 206 NC 507 174 Southeast, 422 424 People X Rail, Cooley versus Wilder, and all of the extras, you guys, as you guys can see. Jury nullification. The jury has an unalienable right to judge both the law as well as the fact in controversy. John Jay, first Chief Justice, United States Supreme Court, 1789. The jury has the right to determine both the law and the facts. Samuel Chase, U.S. Supreme Court Justice 1796, signer of the unanimous declaration. The jury has the power to bring a verdict in the teeth of both law and fact. Oliver Wendell Holmes, U.S. Supreme Court Justice 1902. Central to the history of trial by jury, it is the right of jurors to vote not guilty if the law is unjust or unjustly applied. When jurors acquit a factually guilty defendant, we say that the jury nullified the law. The founding fathers believed that juries in criminal trials had a role to play as the conscience of the community and relied on juries nullifying to hold the government to the principles of the Constitution. Trust in the jury is, after all, one of the cornerstones of our entire criminal jurisprudence. And if that trust is without foundation, we must re-examine a great deal more than just nullification doctrine. Judge David L. Bazelon. There may be no feature more distinctive of American legal culture than the criminal trial jury. Americans have a deep and stubborn devotion to the belief that the guilt or innocence of a person accused of a crime can only be judged fairly by a jury of his peers. This notion is a particularly American one, although it was inherited from English common law during the colonial era. Kentucky resolutions. As series of resolutions drawn up by Jefferson and adopted by the legislature of Kentucky in 1799, protesting against the alien and sedition laws, declaring their illegality, announcing the strict constructionist theory of the federal government, and declaring nullification to be the rightful remedy. Justice. It is the duty of the justice to do justice. In common law, the title given in England to the judges of King's Bench and the Common Pleas, and in America to the judges of the Supreme Court of the United States and of the appellate courts of many of the states. In the most extension since the word justice differs little from virtue, for it includes within itself the whole circle of virtues. Yet the common distinction between them is that which considered positively and in itself is called virtue. When considered relatively and without respect to others, has the name of justice, being in itself a part of virtue, is confined to things simply good or evil, and consists in men's taking such a proportion of them as he ought. Bouvier. So a little bit on justice that I would like to share. I'm not going to really go into any details, but I will put in the chat a little later after this video a link to a gentleman by the name of Christopher Hauser, who I've spoken about before, who talked about what justice means, like the true meaning of justice and how it came from Europe, and it was a lot of just filthy, sexual, devious things that were going on in this time, and that's actually where justice came from. I think it was a Queen Justia or something like that. But it's actually. So we're really not getting justice like we think we are, because justice is a Greek or a Latin word or something like that. So yeah, it's deep, y'all. The language is very, very twisted, and yeah, we have to come up out of this mess for serious. So also I wanted to, before I move any forward, I wanted to give a disclaimer and say that this is not legal advice or legal advice or anything of that nature. I'm not a legal advisor. I'm just reading. This is for strictly education and entertainment purposes only, and all my rights are reserved. I reserve all my rights. UCC 1-308. So moving forward, it says the source of virtue is found in Luke 6:19, and the whole multitude sought to touch him. For there went virtue out of him and healed them all. Therefore, a justice is to reflect divine qualities, as we read in Philippians 4:8. Finally, brethren, whatsoever things are true, whatsoever things are honest, whatsoever things are just, whatsoever things are pure, whatsoever things are lovely, whatsoever things are of good report, if there be any virtue and if there be any praise, think on these things. Okay? Sheriff. America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves. Abraham Lincoln. The country, the county sheriff is the last line of defense when it comes to upholding and defending the Constitution. The sheriff's duties and obligations go far beyond the Constitution. Go far beyond writing tickets, arresting criminals, and operating jails. The sheriff also has an obligation to protect the constitutional rights of the citizens in our counties. This includes the right to free speech, the right to assemble, the right to bear arms. Remember the oath. Sheriffs took an oath to uphold and defend the Constitution from enemies, foreign and domestic. In the history of our world, it is government tyranny that has violated the freedoms granted to us by our Creator more than any other. And it is the duty of the sheriff to protect his county from those who would take away our freedoms from both foreign and domestic. Whether it is a terrorist from Yemen or a bureaucrat from Washington, D.C. So I'm going to let y'all screenshot that because that's some good information to know, I think. I hope y'all can get a good shot. Make sure y'all screenshot. Okay, moving on. Bailiff. Officers who perform the duties of sheriffs within liberty and privileged jurisdiction in which formerly the king's writ could not be executed by the sheriff. One to whom some authority, care, guardianship, or jurisdiction is delivered, committed, or entrusted. One who is deputed or appointed to take charge of another's affairs. An overseer or superintendent, a keeper, protector, or guardian, a steward, spellman, a sheriff's officer or deputy. B1 COMM 344, a court attendant. This must be Black's Law Dictionary, I believe. It is the duty of all of the above to correct injustice in as much as it is in their power to do so. And if correction is not possible, it is the duty of the court officers to report the problem to the protectors of the people, the grand jury, in whose hand justice has been entrusted. U.S. codes. Remedy of the people when rights are violated. So we're about to get into the good stuff, y'all. Y'all drop some comments in the chat. Let me know how I'm doing. I know I'm stumbling over words and everything like that. But let's get some interaction going. Make sure y'all share this out. So like I said, we can help educate our people and let our people know their rights and empower our people so that we won't be out here bold and walking like we know what we're doing and we really don't. And this is why we get hemmed up by the police officers and the courts and everything else, because we don't know our rights. So it's time to get educated. We're in the age of information, and no one should be without this information. So let's pass it on. Let's share. Give me some comments. I like to see y'all interacting with me. I like to talk to y'all as well. Make sure you all click on the link in the description area as well to join the chat. Join our chat is where I'll be communicating with you all more closely. We'll be holding classes. I have literature in there, all types of things. Tomorrow I will be going live for a Q&A meet and greet, seeing where everyone's heads are, just trying to get a feel of everyone. And we're going to be coming together as a community to formulate a weekly class. We'll have a class once a week where we'll come together and go over this information, and I'll take you all through the steps of status correction, and just to be able to assist you all with all of this wonderful knowledge so that you can begin to start correcting the wrongs that have been made in your lives with this with this government. Ever since you were born, there's been wrongs that have been made that you may or may not knew about. And so now that you know, and I'm providing you remedy here and in the Signal group, I'm no longer utilizing Telegram for our group. I wanted to keep things as private and secure as possible. So Signal is the next best thing. And that's what we're going to be using the platform to communicate more closely at. So moving forward, let's get to the U.S. codes, okay? Remedy of the people when rights are violated. U.S. 18, Section 2382, misprision of treason. Whoever, having knowledge of treason, conceals and does not make known the same to some judge is guilty of treason for contempt against the sovereign, and shall be fined under this title or imprisoned not more than 7 years or both. Okay? USC 18, Section 201, bribery. If any public official directly or indirectly gives, offers, or promises anything of value to a person to influence any official act. USC 18, Section 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state in the free exercise or enjoyment of any right, they shall be fined under this title or imprisoned not more than 10 years. Y'all see this? You gotta know your rights. Ignorance of the law is no excuse. This is why so many of our people are locked up or dead now, because we were ignorant of the law for the most part. USC 18, Section 242, deprivation of rights under color of law. Whoever, under color of law, statute, ordinance, regulation, or custom, willfully subjects any person in any state to the deprivation of any rights shall be fined under this title or imprisoned not more than 1 year or both. U.S. Section 18 to 2071. Obviously, something wrong with my chat then, because I can't see nothing. Yeah, I can't see, so I don't know what it is. Yeah, I don't know, y'all, what's going on with my chat. There's always something with YouTube as expected. So let's just move on. I'll see y'all comments or whatever afterwards. And we'll move from there. Yeah, because I can't see not diddly squat at all. I don't know. So let's just move on, okay? Where was I at? USC 182071, concealment, etc. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, documents filed or deposited with any clerk or officer of any court shall be fined or imprisoned not more than 3 years or both. Okay? I'm gonna let y'all get a screenshot of this page too. USC, you probably already are able to, the way I got it positioned. USC 2076. Clerk is to file. Whoever, being a clerk, willfully refuses or neglects to make or forward any report, certificate, statement, or document as required by law shall be fined under this title, or imprisoned not more than 1 year or both. Okay? USC 42, Section 1983. That was the year I was born. Civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state, subjects, or causes to be subjected, any person within the jurisdiction thereof, to the deprivation of any rights, privileges, or immunities secured by the Constitution and law shall be liable to the party injured in the actions at law. Okay, moving on. USC 42, 1985. Conspiracy to interfere with civil rights. If two or more persons in any state or territory conspire for the purpose of depriving, either directly or indirectly, any person's rights, the party so injured or deprived may have an action for the recovery of damages against anyone or more of the conspirators. USC 42, 1986. Action for neglect to prevent. Every person who, having knowledge that any of the wrongs conspired to be done or are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured. 2. All is mine. Okay? So, moving on. Job 41:11. Whoever is under the whole heaven is mine. Ezekiel 18:4. Behold, all souls are mine. As the soul of the Father, so also the soul of the Son is mine. Exodus 19. Now therefore, if ye will obey my voice indeed, and keep my covenant, then ye shall be a peculiar treasure unto me above all people, for all the earth is mine. Psalms 50:12. If I were hungry, I would not tell thee, for the world is mine and the fullness thereof. Y'all hear that? The world is yours and the fullness thereof. There's no reason why we should be hungry. Proverbs 8:14. Counsel is mine, and sound wisdom. I am understanding, I have strength. Number 3. Government by consent. Our founders purposely placed the power of the grand jury in the Bill of Rights to make it clear that it belongs to the people and the government is not to violate it. It is the ultimate power of the people which allows them to consent or not to the actions of their servant government. So the government are your servants, guys. Let's highlight that. So y'all need to know that they are your servants. They are public servants. They have a duty to you, not the other way around. They have a duty to you. Servant, government. The government is your servant. Okay? That is so important for y'all to know. Because they don't have power over you. You have all the power. It also prevents governments from unrighteous prosecutions by forcing the government to seek permission from the people before criminal charges can be filed. If the people refuse, it cannot go forward. By understanding this principle, it becomes clear that the government has no authority to control your behavior, and therefore neither do legislators without your consent. Y'all got to get this through y'all head. The Declaration of Independence says we hold these truths to be self evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. All men decide for themselves whether they want to participate in the institutions of men or not. The United States Supreme Court confirmed this when they said every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow man without his consent. Cruden versus Neal 2 NC 338 May turn 1796. Number 4. Only people can file a criminal complaint. Only people can file a criminal complaint. There are only 3 ways a court can hear a criminal complaint. 1. One or more of the people sign a sworn affidavit that they have been injured. 2. A prosecutor on behalf of the government brings an accusation before the grand jury, and the grand jury either indicts or does nothing. 3. The grand jury, by its own will, can investigate merely on suspicion that the law is being violated, or even because it wants assurance that it is not. And if it finds wrongdoing, it can present it to the court and it must go to trial. No one can second guess the grand jury unless the grand jury's actions violates another's unalienable right. Principles of liberty. Consent and jurisdiction. It's all about consent and jurisdiction. In order to possess liberty it is extremely important that you understand consent. Our servant government cannot do anything without your consent. That's underlined, but I'm highlighting it. So, let me tell y'all a little bit about this, right? They tell us what they're doing on the news. They tell us what they're doing in movies. They tell us what they're doing in the television shows and things of that nature. They're basically telling us what they're doing. And but they cover it up with all this extra mumbo jumbo bullshit that we don't take it serious, and we think that it's just TV and it's not real. But they're actually playing out things right before our eyes, you guys, on TV. Literally. Okay? Consent of authority. Reread in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Any authority our servants have is by our consent. If they act outside their authority, they are subject to criminal charges under U.S. Codes 42 and 18 and liable for damages under U.S. Codes and common law. Consent to indict. The Fifth Amendment states, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Therefore, our servant government requires the people to get an indictment grand jury. Judges or servants have no authority to make a ruling or a judgment on people who are their masters without your consent. In legal terms, when The judge asks you, do you understand? He means, do you stand under the authority of his court? So when you say yes, you give him or her the court jurisdiction over you. So this is a wrong that we got to correct, guys. Let me highlight that and y'all can get that. I'm going to highlight this whole paragraph. It's important. Y'all need to screenshot that and study that. So when you go in court and the judge asks you, do you understand from now on? You say, I do not understand. When the police officer or whomever, the, when they ask you, do you understand? You say, no, I do not understand. That way you won't be giving them jurisdiction under you. And you reserve all your rights under UCC 1-308 at all times. Okay? Get that as a screenshot. All right, moving on. Only people can judge. Our U.S. Constitution only authorizes common law courts, aka courts of record. A court is that of the administrator of the court. The final determinator is the tribunal, who is either the sovereign plaintiff or a jury. Remember, the servant cannot rule over the master. Can the clay rule over the powder? Duh, no, it cannot. Every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Cruden versus Neal. Here is liberty if you do not give a court consent, they have no jurisdiction over you. Under U.S. Codes 42 and 18, so make sure you guys look those up, USC codes or U.S. Codes 42 and 18. That's something for you guys to study and do your homework on, because there's more to it than what's in this book, okay? Most definitely. When you are detained without your consent for violating a statute, you have just been kidnapped, and if the judge sets a bail, he just set a ransom. And when the prosecutor confirms the charges, he becomes part of a conspiracy, and you can put the conspirators in jail and sue them for damages. It's all about jurisdiction and consent. Make sure y'all study that law. All right, the real law. The real law. Okay? The common law is the real law. The supreme law of the land. The code, rules, regulations, policies, statutes are not the law. Y'all see, I put fraud next to it. It's all fraud. All right. Self versus Ray. 61. Legislated statutes enforced upon the people in the name of law are a fraud. Y'all see that? Fraud. They have no authority and are without mercy. Justice without mercy is godless and therefore repugnant to our United States Constitution. Lawmakers were given authority by the people to legislate codes, rules, regulations, and statutes, which are policies, procedures, and law. Policies, procedures, and law. To control the behavior of bureaucrats, elected appointed officials, municipalities, and agencies. So, though they were created, you guys, not for us, but they were created, let's get this, they were created to control the behavior of bureaucrats, elected and appointed officials, municipalities, and agencies. Those codes and statutes were not made for us, but every single day they enforce that shit upon us, right? So this is what you got to do to reverse that and operate in who you are and correct those wrongs that they're making against us, right? So there's two corrections that got to be made. We have to correct them, and they got to correct. We got to correct what we've been doing wrong, and they got to correct what they've been doing wrong. Because everybody's been wrong on both ends at the end of the day. Okay? But we're never given authority to control the behavior of the people. As we read in the U.S. Supreme Court decision, all codes, rules, and regulations are for government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. Rodriguez Rodriguez versus Ray Donovan, U.S. Department of Labor, 769, F2D 1344, 1348, and 1985. Okay? And again, all laws, rules, and practices which are repugnant to the Constitution are null and void. Marbury versus Madison, 5th U.S. 2 Cranch, 137, 174, and 176. 1803. Legislators simply don't have the authority to rule make. Where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436 and 491. God breaks down the laws as follows. And Jesus answered him, the first of all the commandments is, Hear, O Israel, the Lord our God is one Lord, and thou shalt love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind, and with all thy strength. This is the first commandment. And the second is like, namely, this: Thou shalt love thy neighbor as thyself. There is none other commandment greater than these. Mark 12:29 through 31. Although it is a sin punishable only by the judge of the universe to break the commandment to love in your mind, words, and deeds, it does not become a crime punishable by men until your words and deeds are expressed in actions that injure another. Okay, guys? I'm gonna highlight that for y'all so y'all can get that. This whole paragraph need highlightization. This is real sauce right here. This is real sauce. This is empowering. I hate that I can't see y'all comments either. I would love to see what you guys are saying. But I'm gonna read them and I'm gonna respond back to them afterwards. I promise. Okay. All right. So let me let y'all get a screenshot. Give me a second. I hope you guys can see that clearly. All right. Should have been able to get a good screenshot from that. All right, moving forward. It says Thomas Jefferson said, I would rather be exposed to the inconvenience attending too much liberty than those attending too small a degree of it. If one of the people exercises his free will to carry a weapon, travel, practice law, park without depositing money in a meter, use hemp, pharmaceuticals, alcohol, vitamins, minerals, or any other substance for medical and recreational purposes, the legislators do not have the authority to impose a fine, license, or make a crime. Now, this gotta definitely be highlighted because we just went through 2 years of bullcrap. Did we just not? Did we not just come? Did we still going through? They still trying to vaccinate people. They still telling people what to eat. I mean, like, they just They tell you can't smoke marijuana. It's people locked up for years for something that was came from the earth. I mean, people ain't even really committed no crimes, locked up in jail, being made to be slaves, so somebody can be rich, right? Now that got to be highlighted because I was like, no, I don't know about y'all, but that's important too. All right, let's move on. Okay, I got to get resituated in another way, y'all. My grandbaby stuff all over the place. All right. Rights and sovereignty. Only people are sovereign and have rights. Bureaucrats, in their capacity, are not sovereign and have no rights. They have authority given by the people and are subject to the statutes. The state cannot diminish rights of the people. Hurtado versus People of the State of California, 110 U.S. 516. The assertion of federal rights, Bill of Rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis versus Wechsler, 263 U.S. 22 and 24. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436 and 491. There can be no sanction or penalty imposed upon one because of this exercise of constitutional rights. Scher versus Cullen, 481 F 946. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Yik Wu versus Hawkins, 118 U.S. 356, 370. Undersigned is sovereign, and no court has challenged the status standing, or that status standing. Okay. The deprive To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to authority of the entity they have created. That is done by getting them to claim they are citizens of that entity. See Constitution for the USA Amendment for the definition of a citizen of the United States. Licensing liberty. No state shall convert a liberty into a license and charge a fee thereof. So this is why license, like this is why we say you don't need a driver's license to drive a car or to travel, because of this right here. No state shall convert a liberty into a license and charge a fee thereof, right? So why do we have to be licensed to travel, right? We're going to find out further in this book. We already found out in the other books, but we're diving deep into the information, right? Okay. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and fee and engage in the right, liberty with impunity. Shuttlesworth versus City of Birmingham, Alabama, 337 U.S. 262. Remedy for injury. William Blackstone. A legal maxim. Every right, when withheld, must have a remedy, and every injury its proper redress. In the third volume of his commentaries, page 23, Blackstone states two cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. And afterwards, page 109 of the same volume says, I am next to consider such injuries as are cognizable uh, by the courts of common law. And herein I shall for the present only remark that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, military, or maritime tribunals are for that very reason within the cognizance of the common law courts of justice. For it is a settled and invariable principle in laws of England that every right when withheld must have a remedy and every injury its proper redress. 5 U.S. 137, Mayberry versus Madison. The government of the United States has been emphatically termed by a government of laws and not of men. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Marbury versus Madison 5 137 1803. That statutes which would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. Hoke versus Henderson 15 NC 1525 AM December 677 or 677. The right to be let alone is the most comprehensive of rights and the right most valued by civil men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever that means, employed must be deemed a violation of the Fourth Amendment. Olmstead versus U.S. 277, U.S. 438, 478, 1928. Court. The court belongs to the sovereign plaintiff people. Black's Law Dictionary, 5th edition, page 318, defines the court as the person and suit of the sovereign, the place where the sovereign sojourns with the regal retinue, whatever that may be. In the U.S. Supreme Court case Isbell versus Stovall, the court is defined as an agency of the sovereign created by him directly or indirectly under his authority, consisting of one or more officers, establishing and maintained for the purposes of hearing and determining issues of law and fact regarding legal rights and determining issues of law and fact regarding legal rights and alleged violations thereof, and applying the sanctions of the law authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. Judicial notice. Judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. Black's Law 4th edition. Take judicial notice of American Jurisprudence, Book 16, Constitutional Law section, which a judge is bound by oath to obey. Judges sworn to obey constitutional irrespective of opinion and consequences. Constitution rules over statutes. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions and irrespective of the consequences. Thus, it is said that the courts should be in our alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise in accordance with these basic principles. The rules is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal before which the validity of the enactment it is directly drawn into question. If the Constitution if the Constitution prescribes one rule and the statute another in a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. 16 American Jurisprudence D, Section 155, emphasis added. Supremacy Clause. This Constitution and the laws of the United States, which shall be made in the pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws at any state to the contrary notwithstanding. U.S. Constitution. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that all law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. After more than 20 years, that decision still stands. Marbury versus Madison 5, U.S. 137, 1803. Common law is still the law of the land. All cases which have cited Marbury versus Madison to the Supreme Court have never been overturned. See Shepard's citation of Marbury versus Madison. The Constitution was ordained and established by the people for the United States of America, aka government. Therefore, government was created by an act of the people. Therefore, the created cannot trump the creator. If any statement within any law which is passed is unconstitutional, the whole law is unconstitutional. Marbury versus Madison 5, U.S. 137, 1803. Therefore, no legislation. Statutes which would deprive a citizen of the rights of person or property without a regular trial, according to the course and usage of common law, would not be the law of the land. Hoke versus Henderson, 15 NC 1525, American Jurisprudence, December 677. Where rights secured by the Constitution are involved, therefore can be no rule making or legislation which would abrogate them. Miranda versus Arizona 384, U.S. 436, 491. Interpretation in favor of the people. Any constitutional provision intended to confer a benefit should be liberally construed in favor in the clearly intended and expressly designated beneficiary. That a constitution should receive a literal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. 16 American Jurisprudence 2D, 16 American Jurisprudence 2D, Section 97, Berry versus United States 273, U.S. 128. No emergency has just cause to suppress the Constitution, while an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or states' constitutions, public emergencies such as economic depression for especially liberally construction of constitutional powers has been declared that because of national emergency. Hold on 1 second, you guys. Let me get some water. Can you get some water? Of national emergency. It is the policy of the courts of the times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to do that, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution. 16 American Jurisprudence, 2D, Section 98. One moment, please. Whew. Good water. Constitutions must be construed to reference the common law. Summary proceedings are null and void. As to the construction, with reference to common law, an important canon of construction is that constitutions must be construed to reference the common law. The common law so permitted destruction of the abatement of nuisances by summary proceedings, and it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in a sense of a national customary law as distinguished from the common law of England, adopted in the several states, interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the federal constitution could not be understood. 16 American Jurisprudence 2D, Section 114. Shall not infringe. Various facts or circumstances intrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision is in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. 16 American Jurisprudence 2D, Section 117. Irreconcilable conflict between statute and constitution is to be resolved in favor of constitutionality and the beneficiary. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. A clear incompatibility between law and the Constitution must exist before the judiciary is justified holding the law unconstitutional. This principle is in line with the rule that doubts that the constitutionality should be resolved in favor of the constitutionality and the beneficiary. 16 American Jurisprudence 2D, Section 255. Supreme law is the basis of all law. All fiction and law is null and void. Nisi Prius. Nisi Prius courts rely on statutes, which is fiction of law that seeks to control the behavior of the sovereign people of New York and other states, who are under common law, not statutes, and who ordained and established the law. Therefore, legislators cannot legislate the behavior of the people. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law is illogical, for certainly the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict with conflict would be null and void of law. It would bear no power to enforce. It would bear no obligation to obey. It would purport to settle as if it had never existed. For unconstitutionality would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a near nullity or a fiction of law. All codes, rules, and regulations are for government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lack due process. Rodriguez versus Ray Donovan. The common law is the real law. Sorry, y'all. Let me see. The common law is the real law, the supreme law of the land. The codes, the rules, regulations, policies, and statutes are not the law. Self versus Ray, 61. Okay. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The general rule is that a unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the enactment and not merely from the date of the decision so braining it. An unconstitutional law in legal contemplation is an inoperative as as inoperative as if it never had been passed. Such a statute lives a question that it purports to settle, such as it would be had the statute not ever been enacted. Tongue twisters, guys. No repeal of enactment is necessary. Since an unconstitutional law is void, the general principle follows that it imposes no duty, conveys no rights, creates no office, bestows no power of authority on anyone, affords no protection, and justifies no acts performed under it. A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law. No courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby, since an unconstitutional statute cannot repeal or in any way affect an existing one. If A repealing statute is unconstitutional. The statute which it attempts to repeal remains in full force and effect, and where a statute in which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it and will not be permitted to operate as repealing such prior law. The general principles stated above apply to the Constitution as well as the laws of the several states insofar as they are repugnant to the Constitution and laws of the states. 16 American Jurisprudence 2D, Section 256. Congress cannot alter rights. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. 16 American Jurisprudence 2D, Section 258. Rights do not come in degrees. Although it is manifested that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and there are no degrees of constitutionality. 16 American Jurisprudence 2D, Section 260. States cannot license rights. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involves restraints in advance of the constitutional liberties of press and religion, and inevitably tends to suppress their existence. That the ordinance is non-discriminatory, and that it applies also to peddlers of wares and merchandise in is immaterial. The liberties granted by the First Amendment are in a preferred position, since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority. The injury as to whether the state has given something for which it cannot ask a return is irrelevant. No state may convert any secured liberty into a privilege and issue a license and a fee for it. So y'all see this? We be piling up at the Secretary of State at the DMV, trying to get our license and vehicle registrations and IDs and shit, and we don't even have to, right? It's unnecessary. It's not required. It's not law. Like, what the fuck are we doing? Okay. So, moving forward, where do we leave off at? If the state does convert your right into a privilege and issues a license and a fee for it, you can ignore the license and fee and engage the right with impunity. Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262, 1962. Okay? Officers of the court have no immunity from liability. Officers of the court have no immunity from liability when violating constitutional rights. The rights of action created by statutes relating to deprivation under color of law of a right secured by the Constitution and the laws of the United States, and some claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Owen versus Independence, 100 volume Supreme Court Rules 1398, 1982. Maine versus Thibodeau, 100-volume Supreme Court Reports, 25002, 1982. Title 18 U.S. Code, Section 241 and Section 242. If upon conviction you are subject to a $10,000 fine, 10 years in jail, or both, and if theft results, life in prison. Wow. Title 42 U.S. Code, Section 1983, Section 1985, and Section 1986 clearly establish the right to sue anyone who violates your constitutional rights. The Constitution guarantees he who would unlawfully jeopardize your property losses property to you, or loses property to you, and that's what justice is all about. Judges are deemed to know the law and are sworn to uphold it, and can hardly claim that they acted in good faith or willful deformation of law, and certainly cannot plead ignorance of the law, for that would make the law look unintelligent for a knowledgeable judge to claim ignorance of a law when a citizen on the street cannot claim ignorance of the law. Therefore, there is no judicial immunity. Boom! In they face. As long as we don't notice, they get away with it. So share, share, share. Make sure y'all share this out. I'm going to drink some water, okay? Share this with your mama, auntie, cousin, uncles, best friends. You should be reading this to your baby so that they can know the law by the time they come of age and get out here in these streets. So they don't have to be messed with by these tyrannical people that think they rule over us. Constitutional preambles. Both constitutions, U.S. and New York, and the Constitution of any real republic, the operative word is establish and ordain. The people existed in their own individual sovereignty before the Constitution was enabled. When the people establish a constitution, there is nothing in the word established that signifies that they have yielded any of their sovereignty to the agency that they have created to interpret, otherwise would convert the republic into a democracy. Republic versus democracy. This is where it gets good, y'all. Government. We the people are a republic, not a democracy, which is just the first step to an oligarchy. Republican government, one in which the powers of the sovereignty are vested in the people and are exercised by the people, either directly or through representatives chosen by the people, to whom those powers are specially delegated. N. Ray Duncan, 139, U.S. 449. Blase, blase, blase. Y'all can get that right there. Okay? Democratic government. That form of government in which the sovereign power resides in and is exercised by the whole body of free citizens directly or indirectly through a system of representation, and distinguished from a monarchy, aristocracy, or oligarchy. Black's Law Dictionary, 5th edition, 5388. Bond versus U.S. SCOTUS. Recognizes personal sovereignty, June 16th, 2011. Okay. Duties of courts. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachments thereon. Boyd versus United States, 116 U.S. 616 or 635. It will be an evil day for American liberty in the theory of a government outside supreme law finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of principles of Constitution. Downs versus Bidwell, 182 U.S. 244, 1901. We, judges, have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. One moment, please. Let me turn this down. Okay. Cohen versus Virginia, 1821. 6 wheat, 264, and U.S. versus Will, 449, 200. It may be that it is obnoxious. It is the obnoxious thing in its mildest form, but illegitimate and unconstitutional practice get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rule that constitutional provisions for the security of persons and property should be liberally construed, and a close and literal construction deprives them on half their efficacy and leads to gradual depreciation of the right, as if it is consistent more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachments thereon. Their motto should be obsta principis. Boyd versus United, 116 U.S. 616 at 635, 1885. Courts of record are common law courts and therefore courts of justice. At law, Bouvier's Law, 1856 edition. This phrase is used to point out that a thing is to be done according to the course of the common law. It is distinguished from a proceeding in equity. Any court that ignores due process, all statutory courts ignore due process, is not a common law court. Common law courts are courts of record. In all courts of record, the tribunal is the sovereign plaintiffs of the court or the jury. The justice is the administrator and reflects the wish of the sovereign or jury because the people rule, not government servants. The following law of the land proves this point. Let me make sure it's fine. Okay. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to that contrary, notwithstanding. U.S. Constitution, Article 6, Clause 2. Law of the land, due course of law, and due process of law are synonymous. People versus Skinner, California 110, I guess that's California. PD 2D 4145, State versus Rossi. And y'all can see the rest of that reference there. New York State Constitution, Article 6. B. The Court of Appeals, the Supreme Court, including the appellate divisions thereof, the courts of claims, the county clerk, the surrogates courts, the family court, the court of civil and criminal jurisdictions of the city of New York, and such other courts as the legislators may determine shall be courts of record. Courts are divided generally into courts of record and those that are not of record. A court of record is a judicial tribunal having attributes and exercising functions independently of the person designated generally to avoid it, and proceeding according to the course of the common law. In a court of record, the acts and judicial proceedings are enrolled, whereas in courts not of record, the proceedings are not enrolled. The privilege of having these enrolled memorials constitutes the great leading distinction between courts of record and courts not of record. To be a court of record, a court must have four characteristics and may have a fifth. They are: 1. Judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. Jones versus Jones, 188, and the rest of that. 2 is proceedings according to the court of common law. Jones versus Jones, 188, and the rest of that, those references. Then we have 3, its acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony. Okay. Number 4 is has power to fine or imprison for contempt. And the 5th is generally possesses a seal. Okay. The people of the state, as the successors of its former sovereign, are entitled to all rights which formerly belonged to the king by his prerogative. Lansing versus Smith. Okay. Section 3 and 7, a consequence of his prerogative is the legal ubiquity of the king. His majesty in the eye of the law is always present in all his courts, though he cannot personally distribute justice. Fortis 8, his judges are the mirror by which the king's image is reflected. Blackstone's commentary. Judicial immunity. New York judges are under the illusion that they have absolute immunity, but all the cases that are cited making such a claim are without authority, people, and will fail in the federal and state courts in a court of record. Only the people are sovereign. All servants are under statutes and therefore liable to USC 18 and 42. Therefore, where there is no jurisdiction, there can be no discretion. They are not above the law. When they commit a crime, they will go to jail and they are subject to civil suits. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creators of the law and are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its functions is only the more strongly bound to submit to the supremacy and to observe the limitations which it imposes on the exercise and authority which it gives. Okay. U.S. versus Lee, 106, U.S. 196, 220, blase, 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 from 1882. Okay. There is a general rule that a ministerial officer who acts wrongfully, although in good faith, is nevertheless liable in a civil action and cannot claim the immunity of the sovereign. Copper versus O'Connor, 99. Any judge who does not comply with his oath to the Constitution of the United States wars against the Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. Copper versus Aaron, 358 U.S. 178. A judge must be acting within his jurisdiction as to subject matter and person. to be entitled to immunity from civil action for his acts. Davis versus Burris. The courts are not bound by an officer's interpretation of the law under which he presumes the act. Hofsummer versus Hayes, 92, Oklahoma, 32. Where there is no jurisdiction, there can be no discretion. For discretion is incident to jurisdiction. Okay? Piper versus Pearson. Right to practice law. The term liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring children, to worship God according to the dictates of his own conscience. This established doctrine is that this liberty may not be interfered with under the guise of protecting public interest by legislative action. Now, this is a good one to highlight, I think. So we all have the right to practice law. It's the judges and them that don't have the right. They can't practice law, especially from the bench, because they are under a legal system. Okay? See how they switch it up? They try to play word games and shit with us, y'all. It's a game. It's all about language. Okay. Right to practice law. I don't know why it's blurry for me. I hope it's not blurry for y'all. Okay. Let me see if I can clean off my camera. I don't know. It looks blurry to me. A state cannot exclude a person from the practice of law or from any other occupation in a manner or for reasons that contravene the due process clause of the 14th Amendment. Schwer versus Board of Bar Examiners, 358 U.S. 232, 1957. There can be no sanction or penalty imposed upon one because of his exercise of constitutional rights. This practice of law cannot be licensed by any state or state. Schwer versus Board of Examiners, United States Reports 356, U.S. pages 238 and 239. The practice of law is an occupation of common right. Okay? We all have the right to practice law. Okay? We, the people, do. They don't. Because they're not operating in law. All right? I'm going to read a few more pages and I'm going to finish up for today, you guys. Of course, we're going to make this 2 hours. So, like I said, I'm going to read a few more pages and then we'll be done for today. Make sure you guys share this on your social media pages. Like, subscribe to my channel. Please hit the notification bell so that you can be notified whenever I'm going live or putting up a video for you all. It is my duty, it is my honor to be able to serve you all and bring you all this information. If you would like to donate, I do accept donations for my research and development of this information that I have been diligently studying, and I would appreciate your donation. And you can do so by emailing me. Or the information to send me a donation is in the description area of the video. I accept donations by Zelle, or you can Cash App, but you would have to email me if you want to Cash App me, because the Cash App is not mine. It's that of one of my children or spouse. With that being said, I'll continue reading you all. Litigants can be assisted by unlicensed laymen during judicial proceedings. Brotherhood versus Trayman versus um, Virginia. X-Rail, Virginia State Bar, 377 U.S. A next friend is a person who represents someone who is unable to tend to his or her own interests. Federal Rules of Civil Procedures, Rule 1728 U.S.C. Next friend. Members of a group who are competent non-lawyers can assist other members of the group achieve the goals of the group in courts without being charged with unauthorized practice of law. NAACP versus Button, 371 U.S. 415. United Mine Workers of America versus Gibbs, 383 U.S. 715. And Johnson versus Avery, 89. There, every man is independent of laws except those prescribed by nature. He is not bound by any institution formed by his fellow man without his consent. Cruden versus Neal 2, NC 338, 1796, 2 SE. Under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her, except as his or her conduct to others, leaving him or her the sole judge as to all that affects himself or herself. Mugler versus Kansas, 123, U.S. 623, 659 through 660. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. Davis versus Weschler, 263 U.S. 22 at 24. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution. Murdoch versus Pennsylvania, 319 U.S. 105 at 113. The state cannot diminish rights to the people. Hurtado versus California, 110 U.S. 516. The claim of exercise of a constitutional right cannot be converted into a crime. Miller versus U.S. 230 FD 2A. F2D 486 489. If the state converts a liberty into a privilege, the citizen can engage in the right of impunity. Shuttlesworth versus Birmingham. History of the sheriff. While most people in America recognize the sheriff as the chief law enforcement officer, or CLEO, for the county, they would be surprised to know that the office of the sheriff has a proud history that spans well over 1,000 years, from the early Middle Ages of our own high-tech era. The Middle Ages. More than 1,300 years ago in England, small groups of Anglo-Saxons lived in rural communities similar to modern-day towns. Often at war, they decided to better organize themselves for defense. Sometimes before the year 700, they formed a system of local self-government based on groups of 10. Each of the towns divided into groups of 10 families called tithings. Each tithing elected a leader called a tithing man. The next level of government was a group of 10 tithings, or 100 families, and this group elected its own chief. The Anglo the Anglo-Saxon word for chief was Gerefa, later shortened to reeve. So it might be Garifa, later shortened to reeve. During the next 2 centuries, groups of hundreds banded together to form a new higher unit of government called the Shire. The shire was the forerunner of the modern county. Each shire had a chief, which was a reeve. Oh, this is okay. As well, and the more powerful office official became known as the shire reeve. Wow, this is crazy, y'all. Y'all see this? The word shire reeve became the modern English word sheriff, the chief of the county. The sheriff maintained law and order within his own county with the assistance of the citizens. When the sheriff sounded the hue and cry that a criminal was at large, anyone who heard the alarm was responsible for bringing the criminal to justice. This principle of citizen participation survives today in the procedure known as pose pose comitatus. Wow, guys, never knew that. That was an interesting history lesson. How the sheriff became to be the sheriff. The office grows. English English government eventually became more centralized under the power of a single ruler, the king. Let me take a breath, guys. The king distributed huge tracts of land to noblemen who governed the land under the king's authority. The office of sheriff was no longer elected but appointed by the noblemen for the counties they controlled. In those areas not consigned to noblemen, the king appointed his own sheriffs. After the Battle of Hastings in 1066, England's rule fell to the Normans, France, who seized a centralized all power under the Norman king and his appointees. The sheriff became the agent of the king, and among his new duties was tax collection. This dictatorial rule by a series of powerful kings became intolerable, and in 1215 an army of rebellious noblemen forced the despotic King John to sign a Magna Carta. This important document restored a number of rights to the noblemen and guaranteed certain basic freedoms. The text of the Magna Carta mentioned the important role of the sheriff 9 times. Wow, guys, what an interesting story, huh? Over the next few centuries, the sheriff remained the leading law enforcement officer of the county. It was an honor to be appointed sheriff, but it was costly. If the people of the county did not pay the full amount of their taxes and fines, the sheriff was required to make up the difference out of his own pocket. He also had to provide lavish entertainment for judges and visiting dignitaries at his own expense. The sheriff crosses the Atlantic. The first American counties were established in Virginia in 1634, and records show that one of these counties elected a sheriff in 1651. Most other colonial sheriffs or colonial sheriffs were appointed, just as the noblemen in medieval England. Large American landowners appointed sheriffs to enforce the law in the areas they controlled, and to protect their land, American sheriffs were not expected to pay extraordinary expenses. However, and some actually made money from the job. Throughout the 18th and 19th centuries, colonial and state legislators assigned a broad range of responsibilities to the sheriff, which included the familiar role of law enforcement and tax collection. Other duties were new, such as overseeing jails, houses, and corrections and workhouses. As Americans moved westward, so did the office of sheriff and the use of jails. Settlers desperately needed the sheriff to establish order in the lawless territories where power belonged to those with the fastest draw and the most accurate shot. Most Western sheriffs, however, kept the peace by virtue of authority. With the few exceptions, sheriffs resorted to firepower much less often than we have seen depicted in movies and on TV. The sheriff today, there are over 3,000 counties in the United States, and almost every one of them have a sheriff except for Alaska. Some cities, such as Denver, St. Louis, Richmond, and Baltimore, have a sheriff as well. The office of sheriff is established either by the state constitution or by act of state legislature. There are only two states in which the sheriff is not elected by the voters. In Rhode Island, sheriffs are appointed by the governor. In Hawaii, deputy sheriffs serve in the Department of Public Safety's Sheriff's Division. There is really no such thing as a typical sheriff. Some sheriffs still have time to the town drop by the town coffee shop to chat with the citizens each day, while others report to an office in a skyscraper and manage a department whose budget exceeds that of many corporations. However, most sheriffs have certain roles and responsibilities in common. All right, I'm going to read this last page and we're going to finish up for today, guys. It says law enforcement. A sheriff always has the power to make arrests within his or her own county. Some states extend this authority to adjacent counties or to entire states. Many sheriff's offices also perform routine patrol functions such as a traffic control, accident investigation, and transportation of prisoners. Larger departments may perform criminal investigations, and some unusually large sheriff's offices command an air patrol and mounted patrol or a marine patrol. Sheriffs still enlist the aid of the citizens. The National Neighborhood Watch Program, sponsored by the National Sheriff's Association, allows citizens and law enforcement officials to cooperate in keeping communities safe. This is why the new mission of the Indian Sheriff's Association and slogan is building communities of trust is all 92 Indian counties. As the sheriff's law enforcement duties become more extensive and complex, new career opportunities exist for people with specialized skills: underwater diving, piloting, boating, skiing, skiing, radar technology, communications, computer technology, accounting, emergency medicine, and foreign languages, especially Spanish, French, and Vietnamese. So I'll finish there. I'll just read this last piece and we'll finish. Court duty. Sheriffs are responsible for maintaining the safety and security of the court. A sheriff or deputy may be required to extend all court sessions, to act as bailiff, to take charge of juries whenever they are outside the courtroom, to serve court papers, to extradite prisoners, to collect taxes, or to perform other court-related functions. Jail administration. Most sheriff's offices maintain and operate county jails and other detention centers, community corrections facilities such as work release and halfway houses. Sheriffs are responsible for supervising inmates, protecting their rights, and providing food, clothing, exercise, and recreational medical services. As jail conditions continue to improve, sheriffs and their departments are earning increased respect as recognition as professionals. Law enforcement is becoming increasingly complex for the progressive, forward looking sheriff's offices of today. Education and training are the keys to effective job performance. Today's sheriff is likely to have a college degree, a graduate degree in criminal justice law or public administration, and several years experience in the criminal justice system. Your Indiana Sheriff's Association (ISA), under the leadership of Executive Director Stephen P. Lucy, is dedicated to working with ISA membership to ensure that the men and women who protect and serve the citizens of Indiana are the best trained and most qualified. All right. President Ronald Reagan stressed the importance of the modern sheriff in his address to the National Sheriff's Association on June 21st, 1984. He said, "Thank you for standing up for this nation's dream of personal freedom under the rule of law. Thank you for standing against those who would transform that dream into a nightmare of wrongdoing and lawlessness. And thank you for your service to your communities, to your country, and to the cause of law and justice." Justice Scalia, writing for the majority in 1997, in a 1997 decision, said that states are not subject to federal direction, and that the U.S. Congress only had discrete and enumerated powers, and that federal impotency was endeared expressly by the 10th Amendment. He confirmed that the sheriff is the chief law enforcement officer, CLEO, of the county, and also proclaimed that the states retain an inviolable sovereignty. Scalia went even further in this landmark decision, one in which two small town sheriffs headed the feds off at the pass and sent them on their way. Scalia, in his infinite obligation to the Constitution, took his entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day. Obviously, the sheriff is the people's last line of defense against a government gone rogue." All right, guys, so that concludes today's reading. That concludes today's reading of this book, Common Law Handbook for Jurors, Sheriffs, Bailiffs, and Justices. It says justice and judgment are the habitation of thine throne. Mercy and truth shall go before thy face. Okay? So with that being said, I wish I could see you all's comments, but I can't. Yeah, I can't see them at all, guys. So I'm going to go ahead and end the video. Yeah, I'm going to go ahead and end. I thank you all for watching today. Make sure you guys share this out. Remember, I'm going live tomorrow in my Signal channel, on my Signal channel over on Signal to do a Q&A to meet all of you all and get to know each and one of you who are interested in furthering their education in this information. We will definitely be starting classes every single week. We'll probably come together once or twice a week, depending on my availability. I'm going to commit to once a week for now. And then if I, in the future, can commit another day, I will definitely let the public know or let you all know. However, other than that, I appreciate you guys taking the time out to listen to me read to you all today. I hope you all enjoyed the information. It's very, very, very informative. Make sure you guys share this information with your friends and family, your mamas, aunties, nieces, aunties, uncles, sisters, and brothers, best friends, and enemies. Don't leave them hanging. With that being said, I love y'all. That reading drains you a little bit. I'm going to take a sip of water. And anyone who wants to make a donation, just check out the description area of the video. All the information is below. I appreciate you guys. I look forward to coming back. I probably won't be back tomorrow to read. It'll probably be the day after or Thursday. But I will let you know in the community section of my channel. So make sure you subscribe and hit the notification bell, you all. With that being said, it's your girl Shay Marie. And for Shay Marie, I'll see you all later.